counsel to Nnamdi Kanus, Barrister Maxwell Oparal, claimed that Operation Python Dance killed over 38 people, left 15 corpses in attempt to assassinate Nnamdi Kanus in his hometown. Speaking with pressmen in Abuja, Barrister Maxwell Oparal assured Nigerians that Nnamdi Kanus will come out victorious.
This is the first of its kind. This is the novelty where the issue of extradition is being determined by Court of Appeal. And if you watch that judgment yesterday, I think the judgment should be ready by now. If you watch that judgment, the panel cited, majority of the authorities they cited are foreign authorities. That is to show you the one that happened in France, in America, Germany, and what have you. This is the first of its kind. So, and it has shown that Nigeria is not a banana republic. Because when this incident happened, when Nnamdi Kanus was adopted and unlawfully brought into this country, we raised an alarm. You cannot say because you want to destroy Nnamdi Kanus and to destroy the entire country. It doesn't work like that. Because after Nnamdi Kanus, we still have Nigeria. After Malami, we still have Nigeria. We should follow the due process. The due process of the law is that in extradition law, which Nigeria is a signatory, for you to bring a fugitive who committed a crime in your country and run away to another country, you must follow the due process of the law. Extradition law, the law is there, which Nigeria is signatory. Where you fail to follow that particular law, that anything you are doing is a nullity. What do I mean? Nnamdi Kanus is facing a criminal charges. They have a 11 count charge before. Now when we challenge it, out of the 11, 6 was struck out, remaining 5. Then Nnamdi Kanus was granted bail. When Nnamdi Kanus was granted bail, he was in his house at Afaruku. They used Operation Python Dance, went to his house, killed over 38 persons there and left with 15 corpses. They wanted to kill Nnamdi Kanus. They wanted to assassinate him. I'm talking about federal government. Nnamdi Kanus ran for his dear life, and the same government assisted Nnamdi Kanus to run away to Israel. Yes, it's federal government because they are controlling the border. I don't work with immigration. It's federal government of Nigeria that controlled by Nigerian border. So for you to leave Nigerian border, they must be aware. So in other words, they assisted Nnamdi Kanus to Israel. When Nnamdi Kanus found himself in Israel, he deposed an affidavit there that, my lord, I did not jump bail, I did not run away. I'm ready to come back to face my trial. Look at the circumstances by which I ran away. If my lord can guarantee my safety, my security, and my protection, I will come back to come and face my trial. The affidavit is there. He sent the affidavit to us and we will file it in court. While we are waiting for that, for them to give us a date, nothing happened. Only for them, they cited Nnamdi Kanus in Kenya. And they ignorantly, I don't want to use the word stupidly, and they ignorantly arrested him and unlawfully brought him into this country without checking the negativity and the legal implication the thing will have in our own judicial jurisprudence. When Nnamdi Kanus was brought on the 27th of June, they kept him, blindfolded him. On the 29th, they took him to court. And inside the dock, the judge allowed him to speak from the dock without his lawyer. They made an oral application that Nnamdi Kanus should be detained in DSSS. In such a criminal trial, the judge still granted their oral application, and then Nnamdi Kanus was remanded at DSSS for 50 days. As if that one is not enough, they now amended the charge. From that 5, they now amended it to 15. Now, making it 7 good times they amended that charge. So when they brought the charge, and we raised the issue, my lord, look at the law there. Because one thing with law is you don't even need to have a law degree for you to read the law. It's there. My lord, look at the law. The law said for you to try somebody, you should ask them, how do you bring in Nnamdi Kanus? Which is very, very fundamental, because Nnamdi Kanus said that I'm in Kenya. That particular issue should be determined first. If that particular issue is determined and discovered that Nnamdi Kanus, the process of bringing in Nnamdi Kanus is faulty, ask them to go. You decline jurisdiction. We raise it. After raising, he gave us date for ruling. The day of ruling, the judge did not even step in about it. Even when our lead counsel, Mike Ozakume, SAN, draw his attention, my lord, look at this issue. He said that's my ruling. If you don't like it, you can go to Court of Appeal. Of course, it's his ruling. Now, out of the 15 count charges, he struck out 8. Based on that ground, the grounds upon which you struck out the 8, then what is the basis of leaving 7? I have not seen that kind of a trial before. We said, okay, we went on appeal. Lucky enough, the same submission the federal government submitted in Federal High Court, he raised the same submission in Court of Appeal, and Court of Appeal descended on them yesterday. You must read this judgment. In fact, some issues that we won't even know. They brought issue of procedure for extradition, and they reviewed it, and they said that the court shouldn't have allowed them to bring in Nnamdi. No, which undertone? No, it's the law. No, political what? When the United Nations wrote, because Nnamdi's wife and children took Britain to court. Britain, the late Queen, and the current British Prime Minister, what's her name? So refused to declare Nnamdi as a victim of extraordinary rendition. So the wife and the children and the brother, then went to court. They took Britain to court, and the court now ordered Britain that Britain should come and show cause why Nnamdi should not be declared as a victim of extraordinary rendition. So that judgment was given last 2 weeks, and they have served Britain. Britain received it and advised the federal government, please release Nnamdi. Remember, before then, the International Human Rights Organization of the United Nations has also written to Nigeria advising a release Nnamdi and paying Nnamdi compensation, because this thing is going to consume you people. So now the Court of Appeal also gave judgment yesterday and asked that they should release Nnamdi. Remember that before then, Federal High Court in Umuahia has also ordered federal government to release Nnamdi and pay him 1 billion naira. As I speak to you, they have not appealed against that judgment. 1 naira has not been paid. So these are the issues. So there is not like political. When they gave the president opportunity, when he was in Abakaliki, the Ohanese and the elders met him.
But the Attorney General is saying they still have legal reasons to keep on holding on to Nnamdi.
It is very unfortunate. I want to say this thing with a low voice. I called all that cares to know that Attorney General's CV must be reviewed. Attorney General's CV must be reviewed. Why do I say so? I have my reasons of saying so. When Attorney General is talking, the law, he's the #1 law officer of Nigeria. When he's talking, the world should listen. And we're expecting Attorney General to guide Nigerians, especially those who are not lawyers. Because when Attorney General talk and Maxwell talk, that of Attorney General is expected to be followed. Because the presumption is that he knows the law more than me. Now, but see what he just said. The charge has only one charge number. Get it and get it right. The charge, both the old one and the amended one, has only one charge number. And that particular charge was 15. That out of the 15, the Federal High Court struck out 8, leaving 7. Out of the 7 was quashed yesterday with a heavy comment saying that Attorney General and the federal government ought not have filed those charges against Nnamdi. So as we speak now, there is nothing before the court, both in the Court of Appeal and the Federal High Court.
Atoda Babatunde, GTV Africa.